National Asbestos Enactment. Various U.S. policymakers have attempted to acquaint laws with boycott the dangerous mineral in the nation, yet they all have fizzled. As more instances of mesothelioma surface, we can trust that officials at long last put a conclusion to utilizing items as a part of America that contain asbestos. The perils of asbestos are notable in the U.S., albeit few would debate the significant well-being dangers identified with introduction. America does not have a thorough government law tending to the issue. For sure, clearing national enactment about asbestos has demonstrated a battle. Rather, those issues to a great extent are left in the hands of individual states, which frequently have distinctive ways to deal with managing dangers and cases. Most government and state asbestos enactment in the U.S. was roused by a similar two concerns: open well-being and financial concerns. The advancement of these worries can be followed back to the mid-20th century. By then, utilization of asbestos in the U.S. had outperformed that of whatever remains of the world. History of U.S. asbestos enactment. Government enactment to guarantee that inquirers can be made up for infection, death toll and loss of wages has likewise been constrained. Government laws were passed to make remuneration frameworks for different sorts of petitioners. The Dark Lung Benefits Act made a program for U.S. coal mine workers. Nonetheless, a comparable program has not been set up for individuals who are tired in light of asbestos introduction. 1930s. By the 1930s, medicinal confirmation had effectively connected presentation with destructive maladies. In spite of the fact that makers thought about the early confirmation, a considerable lot of them didn't caution laborers or the general population about the risks and potential future well-being issues. Routine utilization of asbestos in development and modern items proceeded. 1960s, 1970s. Since related illnesses don't surface until decades after introduction, the well-being dangers made by this presentation did not get broad open consideration until the late 1960s and the 1970s. That is when casualties progressively documented claims against makers for their wounds, guaranteeing those producers purposely made them wiped out. Before long, the well-being dangers of asbestos were too enormous to stow away. Through the late 1980s, a great part of the consideration encompassing asbestos concentrated on reduction, which includes expelling or containing asbestos from existing structures. There were likewise calls for laws to boycott the utilization of the dangerous mineral. Amid the 1970s, the U.S. government provided rules to point of confinement asbestos introduction. These rules were trailed by more government, state and neighborhood open well-being laws amid the 1980s. Exhibit A. U.S. Senator Patty Murray, Democrat, Washington, supported the Boycott Asbestos in America demonstration of 2007, yet it passed on in Congress. In 2009, she likewise supported a bill that prompted to acknowledgement of September 26 as National Mesothelioma Appreciation Day. Murray, a long-term advocate for asbestos mindfulness and research, keeps on posting these issues among her administrative needs. Enactment. Real enactment on asbestos reduction and tort change have been considered at the government level. With regards to asbestos reduction enactment, the U.S. Ecological Security Organization, EPA, and the Word-Related Well-Being and Well-Being Organization, OSHA, are the fundamental government offices accountable for upholding these laws. The EPA and OSHA are instrumental in the development of asbestos reduction suit in light of the fact that both offices manage laborers, for example, those in the development business, who regularly come into contact with asbestos. One of the greatest dangers to those unreasonably harmed by asbestos introduction is the Assisting Asbestos Asserts Straightforwardness, Reality, Act. It would require asbestos trusts to freely uncover data about the settlement terms amongst trusts and inquirers. Current state and government laws consider these arrangements private and secret, not subject to revelation or allowable in court cases. The first bill was presented in the U.S. Place of Agents in 2013. The bill passed and was sent to the U.S. Senate, where a comparable bill was introduced in 2014. Another congressional session in 2015 documented both adaptations of the recommendations. Nonetheless, Representative Blake Farenthold, Republican Texas, presented another adaptation, H.R. 526, in the U.S. House in January 2015.